Good afternoon. It is 4:31, and because we have a quorum, I want to call it to order, but then we are going to wait for our additional members to make sure they're here. We got one. So we will open it for a motion to call this work session to order.
Mm.
Oh, we perfect. Let's go. Wonderful. With that, we will call this Lance, can you give me a motion to order the to bring to order the work session?
So moved.
With that motion, can I get a second to bring the work session to order?
Second.
Here, first and a second. All those in favor show by a sign of aye.
Aye.
All those opposed, the same. Hearing none, we are called to order. What we have in our work session is our presentation and training for Religious Land Use in Institutionalized Persons Act, or RELUPA, presentation and training provided by Dan Dalton of Dalton and Tomich. If I'm mispronouncing that, I apologize. PLC, and I think they are on at current, so we will turn it over to them.
Great. Well, good afternoon, everybody. It's nice to meet you. My name is Dan Dalton, and you did get it right, Dalton and Tomich. It's very nice to meet you all. Can you hear me okay?
Good afternoon, Dan. Thank you for being with us. I'm not sure if you are on video or not. I just want to make sure if you are that we can see you.
I am on, yes.
You said you are not?
I am. I am on
Oh, you
video.
are. Can we get his video up? Make sure or if he has a presentation or anything, at least that
I
first page can be pulled up.
I do.
Dan, we want to thank you for being with us. Let us get set up here on our end. We're going to adjust the volume a little bit so we can hear you a little better.
Okay.
Wonderful, Dan. If you are with us, we are up
Yes.
on the first page, Brunswick, Georgia, on top, and so we will turn it over to you.
Great. Well, thank you. And it's nice to meet you all. Thank you for having me today. Again, my name is Dan Dalton. I'm here in Detroit, Michigan, where I'm sure it's much, much colder than Georgia. And it's a real pleasure and a real honor to be with you today. So I'm going to give you a brief overview of RLUIPA, the Religious Land in Use and Institutionalized Persons Act, give you some practical tips, and leave it open for some questions at the end. I have about 45, 50 minutes of a presentation and 10 minutes open for questions. And hopefully this will be some value to you, and we'll go from there. I want to thank Brian Corey for his help in retaining us and working with us through this matter. So the question before us today is what is the Religious Land Use Act and the Institutionalized Persons Act, also known as RLUIPA? Well, it's a federal law, the last federal law unanimously adopted by Congress back in 2000. How did it come to begin? Well, it came through a series of case law that really started in the 1700s. There's a case called In re Pearson's Estate. It's not on here. And in that case, English courts, this is before we had case law in the United States on this part, but English courts allowed, through the common law, for courts to divine the original intent of a church in a religious property dispute. So if there was a split in the church, kind of like right now the United Methodist is going through splits, and you had the Episcopal Church and you had schisms in the Presbyterian USA. In order to determine who got the building, who owned the real estate and the personal property, the Pearson Court decided that a civil court could divine that ownership issue by determining which branch, who was leaving or who was staying, was closer to the true doctrine of the church when the church was formed. In 1871, however, the Supreme Court, in a case called Watson versus Jones, decided that really did go too far. It violated the Establishment Clause because it would require churches to determine doctrine or discipline. So the idea of church autonomy doctrine came to be through the Watson versus Jones decision. In 1878, just a few years later, in Reynolds versus United States, the Supreme Court was faced with a specific issue of the free exercise clause and what is the breadth of that clause and the enforcement of that. And in that case, the court said that religious beliefs are protected through the free exercise clause, but actions in the name of religions is not. And that was a case involving polygamy. So the court made it very clear that we're not going to challenge your religious beliefs. We're not going to look into that particular issue. But if there's an action that harms the person, the state has the right to regulate that matter. Moving forward to 1940 in Caldwell versus Connecticut, the Supreme Court incorporated the free exercise clause via the 14th Amendment to the application of states. So now it applied to state law challenges. And in 1963, the dispositive case, Sherbert versus Varner, was decided. And in that case, what the Supreme Court said is that a state action cannot deprive an individual of their free exercise of religion. In that case, it was having Sundays off because of religious beliefs, unless there's a compelling governmental interest using the narrowly least restrictive means to use or enact that state law. And with respect to that, you had to show, if a plaintiff showed a substantial burden on the religious exercise, there was a violation of the free exercise clause. From 1963 to about 1990, the law was very clear on this particular point. And in Wisconsin versus Yoder, a case involving homeschooling for Amish children, the court reaffirmed that Sherbert versus Varner test as well. But in 1990, everything kind of changed in a case called Employment Division versus Smith. And in that case, the Supreme Court, through Justice Scalia at the time, held that government cannot compel religious exercise. In other words, that's this truism since the nation was founded. Can't compel religious exercise, but what it can do is adopt generally neutral and applicable manners and laws. And as long as they're applied evenly and applicably, then that would not violate the free exercise clause. That changed the Sherbert versus Varner dynamic dramatically at that particular point in time. And the Supreme Court affirmed that standard 3 years later in the Church of Lucumi Bayou versus City of Hialeah, Florida, where in that case, the City of Hialeah specifically targeted an ordinance towards a specific religious group. And the court said, if you target, or as Justice Kennedy wrote, you gerrymander your ordinances and your laws towards a religious right, that is no longer neutral or generally applicable. So it has to be free and clear up for that point in time. So what happened then is in this post-Smith world, municipalities used generally neutral applicable laws to deny church uses within cities. So when they wanted to find that deny a church use because of loss of property tax on the property, they would do that. So taxables or rateable properties were held to be by the courts generally neutral and applicable, and a municipality could deny that use. If the city said there was too much lighting or noise or traffic or other generalized concerns, meaning neighbor complaints, they don't want a church in their neighborhood or religious use, a mosque, a temple, a soup kitchen, whatever, a court would use the Smith case to deny that particular use. And Congress found that to be a problem. And so they would, when the Congress had looked at comprehensive plans and zoning and subdivision rules and historic preservation, and all these examples where municipalities were using their municipal authority to deny a religious use, and found that, hey, this is a problem that we have throughout the United States. We want to elevate the free exercise clause and the right to religion by enacting laws to protect that. So in 1993, Congress enacted the Religious Freedom Restoration Act. And that was a very broad law that protected all types of uses, that related to the free exercise clause, from employment to zoning to everything throughout. But in 1997, the Supreme Court invalidated RFRA as it was applied to states in a case called City of Bernie versus Flores. And so Congress had to go back in 2000. They tried a couple times between 97 and 2000. In 2000, Congress found two things that they could agree on, that there would be essentially federal preemption on zoning, and that was land use and zoning, and the other was prison fellowship. If you remember the Chuck Colson prison fellowship, where prisons used to be able to stop religious exercise inside, and Congress said, no, we want to have religious exercise in prisons. So RLUIPA was formed through that. That's how you get religious land use and institutionalized persons in this matter. And that was the last law unanimously adopted by Congress in 2000. And it was really adopted in the land use context to address hidden discrimination and unfair treatment in the land use process, such as using taxable tax spaces to preclude a religious use, or using lighting, noise, and neighbor complaints to preclude a religious use as well. And so that's kind of why this law was enacted. And the Supreme Court recently recognized that in Holt versus Hobbs, by saying that RLUIPA was enacted to provide very broad protection for religious liberty, and provides greater protection actually than what the free exercise clause provides. So, what are the types of claims that are available under RLUIPA? There's 5 claims, but there's really 2 main ones that we'll talk about today. There's substantial burden claims, there's equal terms claims, non-discrimination claims, exclusions claims, and limitations. Exclusion claims you don't really see much anymore. That's where zoning codes specifically excluded religious uses from their community. Unreasonable limitations there's some claims involving that, but the primary one is substantial burden in equal terms. So in all contexts of RLUIPA, with respect to the land use side of this, what Congress provided is it broadly defined what religious exercise is. And it said that it's any exercise of religion, whether or not compelled by or central to a system of religious belief. So what a court will do when faced with this particular issue is it's not going to divine whether this is a religious exercise or not based on the city's objection to it. It's going to say as long as it's a sincerely held religious belief, and it's not frivolous, then we'll allow that to be religious exercise. Justice Gorsuch wrote an opinion called Yellow Bear when he was on the 10th Circuit that basically said that as long as it's not fraud against the court, we're gonna determine it's religious exercise. Congress also said that religious exercise is the use, building, or conversion of real property for the purpose of religious exercise, and whether it's used or that intends to be used for that particular purpose. So again, a building, a structure, real estate, that falls within the concept and the scope of religious exercise under RLUIPA. So as it has been interpreted since it's been enacted about 26 years ago, religious institutions are more than just a house of worship. It's more than a church, temple, synagogue, or mosque.
Dan,
Yes.
would you like us to hold questions to the end or ask questions per section as you go through?
If you wouldn't mind holding them to the end, that would be great.
Not a
Yeah.
problem. Thank you.
Okay. So religious institutions include schools, community centers, hospitals, homeless shelters, all of those things, senior housing, that would also fall within the scope of religious uses. It's not just simply Wednesday evenings and Sunday mornings anymore. It's every day of the week, and the uses that go with it within that. So when you look at the substantial burden provision of RLUIPA, it applies if there's under a program that receives federal funding, not allowed to, so that doesn't necessarily fall into play. When it involves interstate commerce, and typically that's when you buy the religious entity is buying like product from out of state, like steel or wood or something like that from out of state to bring it in. The biggest one is the third part, the imposition of an individualized assessment for the use of that property. So an individualized assessment under RLUIPA is basically the application of your land development code or your zoning code. Is it if your zoning code is a land use regulation, which most are, in which the government makes an individualized assessment, which is application of that land use code to a particular project, always does, and it permits the government to assess the proposed use. It's an individualized assessment. In that case, there's a City Walk case out of northern Florida, the Tallahassee area, that we litigated that kind of talks about that particular issue, and that's where that comes into play. A land use regulation is defined under the Act as a zoning or landmarking law or application of such a law that limits or restricts the claimant's use or development of land if the claimant has an ownership, a leasehold, an easement, a servitude, or other property interest in it. So what does that mean? A zoning law is your land development code or your zoning regulation. A landmarking law is your historic designation rules. So if you have if your city has historic designation ordinance and are using that to block a church, for example, from renovating its property or using its property or whatever, that would fall within RLUIPA. That's kind of something that a lot of larger cities are doing now, where they want to maintain the architecture and the use of a church that's quite frankly not being used or needs to be closed. And they're using landmarking laws to block that from occurring. This is where RLUIPA falls into play with that. The substantial burden provision under RLUIPA provides the language that we have here on the screen. You can't implement a land use regulation in a manner that imposes a substantial burden on religious exercise. So that's the burden of the plaintiff that we have to prove, unless what a municipality has to prove a compelling governmental interest in the least restrictive means of furthering that interest. So what does that particular mean? In the 11th Circuit, where Georgia is located, a substantial burden is not defined in the statute. It's defined in the case law. So in the Time Mediation Center, this is a case out of Alabama, the 11th Circuit defines substantial burden as akin to significant pressure which directly coerces the religious adherent to conform his or her behavior. So what that's been interpreted to mean is if you block a particular use by using your zoning or your landmarking laws, that becomes a substantial burden. So if you're not allowed to use a particular building project real estate for zoning use, that could be a substantial burden. Or it's not necessarily to completely prevent that use, but if you have to modify your behavior. So if you want to have let's say a mosque that comes in to serve a community of 1,000 families, but you only allow an area for 20 families to worship, that would be a substantial burden. So the 11th Circuit has this handy 6-factor test in the Thai case that we outline of when a substantial burden occurs. And it's just important when you've got a great attorney and you have your attorney and your planner get together and work with you to go through these factors to determine what is that meaningful nexus. What is the has there been a demonstration of a need for new space, and going through all of those factors that are outlined on the screen. And again, just I've sent Brian the PowerPoint as well, so you'll have all this information if you like in the future. So what are some examples of substantial burdens in the 11th Circuit? If there's nowhere to locate in the jurisdiction. So you might allow for zoning for religious uses in specific area, but if there's no land available, there's nothing's for sale, or maybe it's in an area that's like underwater for environmental reasons or whatever the case may be, that's probably going to be a substantial burden. If you're unable to use property for religious purposes, so if you allow like perhaps an office building to be used by a church, but you don't allow that church to worship there, it's probably going to be a substantial burden. If you impose excessive and unjustified delay, uncertainty, or expense, where you're not going to make a decision, but you require the party to return with more studies and more meetings and more decisions to be made over and over and over and over and over again where you keep moving the end zone or the goalpost, I should say, that's going to be a substantial burden. Or there's unwillingness to compromise or bad faith, that would be a substantial burden. However, not everything's a substantial burden. So if a municipality, if a religious use does never seeks a permit, and just goes in tries to be in a community where you're required to get a conditional use permit, that's probably not going to be a substantial burden. Or where there's no reasonable expectation of an approval, where the property is zoned, for example, for residential use only, and a church wants to put in a 100,000 square foot building with an acre of parking, that's probably not going to be a substantial burden in that particular area. Or if the denial has a minimum impact, in other words, the church can go to another location within the city, or it doesn't really impact the religious exercise of that particular church, that probably won't be a substantial burden either. These are very fact-intensive cases. The case is determined at the decision-making level. So with your planning board or zoning board or your town board, it's going to be somewhere in there that's where your decision is going to be made. So you really want to make sure you have a good understanding of what a substantial burden is before you make the decision, to make sure that your record is defensible somewhere down the road. A good case to kind of consider is the Vision Warriors Church case versus Cherokee County. And in that case, there was a faith-based substance abuse rehabilitation ministry that purchased property to operate a residential program. So this is very common. There is a program called the Oxford Houses that started decades ago for men and women coming out of treatment for alcohol abuse, where somebody would be living in a condition that they would continue to go back and be addicted to drugs or alcohol or whatever. They'd go into a hospital for DTs or medical treatment, and then be released back to where they went before. They're more likely to fall back into the addiction. Oxford House is a place to go so you can come out of that addiction area. And this is the same type of facility. And there's a lot of these facilities all throughout the United States on a religious basis where they use religious training to do this. And in the Vision Warriors case, neighbors complained. They were concerned about this particular use, and the county ultimately denied the particular use. And there's a lawsuit, and Vision Warriors case was actually dismissed by the district court. The 11th Circuit, however, reversed and remanded the case, using the court to use the time mediation factors to determine if there is a substantial burden. And where the district court went wrong in that case is that it said that the county won because it did not effectively bar all the uses of the property, and that was the wrong standard to use. And the court said that the district court uses a more demanding standard than what the law provides. So it's just important. It's just one of those cases where I think it's important. These are very factual determination cases, and it's very important to kind of sit down and think through how you're going to evaluate a application before you make that final decision and vote, so you don't find yourself in a lawsuit down the road. So going back to a substantial burden, once a religious use demonstrates a substantial burden, then it becomes what's called strict scrutiny, which is a legal term. The burden shifts over to the municipality. And at that point in time, the municipality has to show that the interest is in furtherance of a compelling governmental interest. And this is a very high burden to prove. Compelling governmental interest is about the highest level of scrutiny that is faced by a governmental entity. So not only do you have to prove the compelling governmental interest, but you're also going to have to prove least restrictive means. So if you deny the use completely, that would be a violation of least restrictive means, because the idea is there something else that we could do besides a denial or an effective denial with this matter? So it's a very high standard. And as a result of these matters, you'll see large jury verdicts and attorney fees as well, because the statute provides for a prevailing plaintiff, a prevailing religious use, their attorney fees are going to be awarded in addition to damages. So there's really three buckets of damages that a religious use is entitled to. One is attorney fees, and that kind of is by statute over on one side. The other is economic damages, which is your out-of-pocket loss. So if there's an increased cost of borrowing or financing a project as a result of a denial, or increased cost of construction, there's the construction costs are always going to increase. That'll be damages. Or something you have to lease a space for a time period, and as opposed to being able to use the space, that will be damages. Think of economic damages as all those damages that arise because of but for the denial of the use. That's your second bucket. Your third bucket of damages is non-economic damages. So think of that as the constitutional violation. So let's say somebody comes to your city council meeting and you have public comments and 10 people get up and say their thing. The 11th person gets up, you say, no, I'm not going to listen to you. We're not going to allow you to speak. Their rights are violated. So what is the damages that flow from that? And there are different ways to calculate that, but that's a third bucket to kind of consider in those matters. And those are just things that you need to kind of be aware of. The second prong of our loop I'm just going to talk about today is equal terms. Equal terms is kind of what how you kind of think about it is if you allow a secular assembly use, you got to allow a religious use. So if you allow a theater, if you allow a city hall, a library, a park, funeral home, a place where people gather and assemble, but you don't allow religious use, you're probably going to violate the equal terms provision of RLUIPA. Under the 11th Circuit, the courts have come up with this test, which is that if the plaintiff is a religious assembly or institution that's subject to a land use regulation that is treated on less than equal terms as a secular assembly use, then you violated RLUIPA. And there's two types of equal terms challenges. One is as applied, and the other is facial. A facial challenge is to the text of the ordinance. And the text of the ordinance is if an ordinance plainly says you can have a theater, a governmental building, a library, funeral home, park, any other place of secular assembly, but does not allow for a religious assembly, that's going to violate RLUIPA. In some districts as well, if you allow those uses, but you allow a religious use through a conditional use permit, that will probably violate RLUIPA as well. So that would be your facial challenge. Your as applied challenge is when through discovery and through a hearing where it's determined that you were for this particular project you were treated differently than another project pursuant to the ordinance, you're going to have an as applied change. So if you allow a movie theater to be built, for example, that has all sorts of parking and lighting and everything, but you don't allow a church to be built, claiming that parking and lighting is too much, you're probably going to violate the equal terms claim of RLUIPA. The non-discrimination provision of RLUIPA provides intentional discrimination, so you can't discriminate from one religious assembly or institution against another. So if you allow a Catholic church but don't allow a Baptist church, you're probably going to violate that non-discrimination clause. It doesn't really happen a lot. It does happen, but it doesn't have a lot. But it's just something to be aware of. Exclusions and unreasonable limitations. We talked a little about exclusions where there's a total exclusion. You don't see a lot of those cases anymore. And you have unreasonable limitations. If you, for example, allow for a site plan, but in that site plan, you limit the number of parking or the size of a building that would just not allow the entire church to meet or congregate or worship together, you're probably going to violate that portion of RLUIPA. You should know that, however, that if you're sued for a substantial burden claim, Congress provided a safe harbor provision, a way to fix it. And that safe harbor claim provides that if you fix it, then your damages end at that particular point in time. So once you change your ordinance, then you no longer have that particular issue. So we had the case in Jacksonville Beach, Florida, for example, where during trial they changed the ordinance to moot the claim at that particular point in time or to end the claim. You still have damages backwards from when the application was denied until that specific date, but it allows the claim to end and this is just for a substantial burden claim at that point in time. And the 11th Circuit has, again, a three-part test for determining the safe harbor provision. So why are we talking all about this? Well, a lot of times what communities do is they think of religious uses as something that takes away assets from their communities, that imposes a cost in the community that they don't get back. But just to push back on that a little, there's been a lot of studies on this particular issue, and the studies all demonstrate from both secular and non-secular groups that religious entities provide a specific value to the local community. It provides certain manners or offers services that a community can't offer. So in this one study from Penn State, for example, it talked about the value of a congressional use of providing after school care, providing helping people gain employment through work skills, providing capital enhancements and crime prevention and reduced crime rate and volunteer hours and things like that. So religious uses generally provide an asset to the community. If you look at the real estate studies, I'm sure real estate brokers are going to say that, well, if you have a religious use, it's going to decrease the value of your specific neighboring properties. But the studies remarkably show that actually it increases the value because of the upkeep and the use of that religious use next door. So just want to keep that in mind for you, that the value of this of having a religious use in your community is much greater than what any property tax could ever pull out of that particular area itself. And again, these are different residential property values. We could provide you the studies that you can look at to verify that for yourself. So here's, I think, the point of the conversation I wanted to spend a little bit more time with you, which is just in speaking with your attorney, what strategies can you have to avoid a future RLUIPA claim? How can you avoid this in the future? And I know I'm talking against my own interests because I represent religious uses in this matter, but I'm just going to talk in general in principle, so you don't find yourself in a position again of being sued by the Department of Justice or another religious entity somewhere down the road. When we look at successful RLUIPA decisions that have been successfully defended by communities, you look at a couple things. One, the very first thing is the response of the governmental entity. If the governmental entity from the start comes out and says, we will never approve this religious use, you're going to find yourself in court. If you're opposed to religious use, you don't want that church, that mosque, that homeless ministry, that soup kitchen in an area where zoning allows for it or should allow for it, you're going to find yourself on the receiving end of a lawsuit somewhere down the road. So the important thing is to treat these religious uses fairly. The second big thing is when you have neighborhood output or negative opinions from neighbors. That generally drives most decisions in these matters, where the local community, the planning department, and your attorneys will recommend approval, but the neighbors don't want this particular use in their area. That is generally going to deprive, and you're going to find yourself on the receiving end of a lawsuit. So you might have 5 or 10 or 100 people at a public meeting opposing this, but you got to remember you're representing a community of thousands, and those 100 people don't speak to the entire community, and those 100 people or whatever that come out against you and speak against this particular use in your area are the ones that are you can't allow them to drive your decisions in this matter. So make sure you kind of keep that in mind. And generally speaking, good communities we see will then allow this matter to diffuse a little bit by, taking all the matters, under consideration, and then, delaying a decision and having that decision later, or doing something else to address neighborhood concerns. The other thing is to examine your land use regulations affecting religious uses and how those regulations are applied. So this is where you want to have a good planner kind of go through your zoning code and compare what the difference is between approved uses and non-approved uses for religious entities, and see what are we allowing here that are secular uses, and versus what are we doing to preclude religious uses, and why? Why do we do that? A lot of times you'll find in your zoning code, for example, things that have been there for a long time that nobody really understands why that is. A good example is parking. A lot of zoning codes say that you have to have one parking spot for every 10 foot of pew. So if you have pews in a church, for example, why is it 10 foot of pew? Why is it one parking spot for that? Or four seats, for one parking spot, when generally two people drive in a car as opposed to four these days on average, things along those lines. So you want to kind of take a deep dive into your zoning code with your professional and determine whether there's something within your regulations that treat a religious use unfairly or differently than a secular use. If you're dealing with an enforcement action for land use, you want to use extra care. So if you have a religious use that is going beyond the scope of what they've been approved for, and that religious use comes in for another building or expansion of their building, and you deny it because of a past behavior or whatever, that's probably going to give rise to a RLUIPA action. So you just want to kind of be able to divine or separate the two, what happened in the past with what's being asked for today, to come up with something down the middle that everybody can live with in the future. And you want to consider that like how you would treat an adult use. Remarkably, the case law for church uses and adult uses is pretty consistent. So keep those type of uses in mind when you're evaluating these matters. I'd also recommend establishing an internal review process when enforcement arguments actions target a religious use. So when you have a religious use come into play, get your departments together, your planning, engineering, police, fire, legal, have them look at the particular use globally first before you have meetings, before you have your pre-meetings and your post meetings and your public meetings, to determine what is it that we all need from our things to make this work, and to make this fit, and how do we make this work and fit to move forward. And so you want to make sure that churches or any other religious uses aren't being singled out, but again, they're being treated fairly. You want to be cautious about departing from precedent when you're handling land use applications. Again, if you're allowing a religious use, I'm sorry, a secular use like a theater, but you're not allowing a religious use, these departures lead to RLUIPA claims. And importantly, be less legal and use more common sense. Treating church representatives or religious representatives fairly and with respect goes a long way. And seek to use good faith and engage with the leaders from religious entities. They all know going into it is they have a list of things that they like to have and list of things that they need to have. The like to have list can go away as long as they get the lead to have matter occurs. I can tell you by representing religious uses for the last 25 years that I've never had a religious use that wanted to file a lawsuit. Not once. Every single time when a lawsuit's filed, it's the matter of last resort where they bought a piece of property that they can't use because of zoning, or they're being treated unfairly by a zoning official or a land use official or a zoning board or planning board. Nobody, no religious use wants to go through a lawsuit. Guarantee you that. They just want their use. They want to be treated fairly. They know that there's no pass under the zoning laws, that because they're a religious entity, there's no free pass, but they want to be treated fairly and allowed to be in a community to provide the good that we noted before, what religious uses can do for this particular community. So you want to maybe consider sensitivity training for some of your planning officers or elected officials to raise awareness of religious differences and cultural differences. Um, for example, when I was on a city council for 3 terms, and we went around to different uses, religious uses, to meet people and find out what their needs are. So, going to a Sikh temple, for example, or Orthodox church, or a synagogue, or Chabad, or Protestant church and Catholic church, just so everybody kind of got an idea of how different people worship and what their needs are. Because you kind of come into this thinking of, I worship this way, or I don't worship, so I don't know what you need. So it's really helpful to get that awareness if you can and you have the time. And it's a lot less costly and a lot less time consuming than going through a lawsuit in this particular issue. So you might want to consider, being open to those meetings and meeting with other people. Real briefly, last few minutes, I would kind of want to cover a couple other things with you. In addition to RLUIPA, the free exercise clause kind of works hand in hand with RLUIPA claims. Under recent Supreme Court decisions, starting with the called the Tandon case, Tandon versus Newsom, which was a 2020 case that came out of COVID, the Supreme Court has very much taken a deferential view towards religious uses when they're treated unfairly by governmental entities. So Tandon involved where the state of California allowed for casinos to remain open, allowed nail salons to remain open, where you're kind of next to each other, allowed Hollywood to their musicians and their choral groups to remain open and to do their work, but precluded any type of religious use to be open. And the Supreme Court said, no, you can't do that. You have to treat churches and secular uses identically. If you're, the Justice Barrett's line in the Tannen case, if you allow a Hollywood chorister to sing, then you have to allow people to sing in a Catholic church or a Protestant church or whatever the case may be. So be aware that right now that free exercise clause, since Tannen versus Newsom and more recently in Union Gospel Mission versus Seattle, that the free exercise clause is expanding. It's going to get broader and broader with this particular court. So you want to be aware of that particular issue. You want to be aware of the Fair Housing Act. That's a federal law that we talked about a little bit earlier, involving the Oxford houses and a couple other type of uses where you have a drug and alcohol rehab place that comes in. You can't discriminate against them. There's a whole line of case law that talks about intentional discrimination, overtly or facial discrimination under the Fair Housing Act that you want to consider. Third thing, it's not on the slide, but you want to consider is a lot of states, and I believe Georgia is one, is they've enacted their own Religious Freedom Restoration Act. So after the city of Bernie decision in 1997, a lot of states enacted their own state laws that addressed these issues, where they kind of mirror the Religious Freedom Restoration Act, involving substantial burden, the whole 9 yards. And it provides for equitable relief, and it provides for attorney fees, the whole thing. And there's a whole separate body of case law that addresses those particular issues. So you want to be aware of that as well when you're thinking through these matters. So that takes us for 45 minutes. And how about that? I got right on the nose there. Feel free to reach out with any questions that you might have. And happy to talk with you on this matter. And we've got 15 minutes for questions. So I'll open it up.
Dan,
And
thank you. We'll open it for questions to the commission. That's
And
any.
if there are no questions, that's great too. But hopefully I was very complete.
Now I have a couple of questions.
Yep.
Sure.
So in hearing this information and understanding the situation in which we were in, that brings us to the circumstances that we're now dealing with and having to go through this training. Is this training I got several questions. Designed to be some type of sensitivity training? No? Okay.
No, I think it's essentially, Dan and I talked, it's informational, educational as it relates to RLUIPA. And it helps explain, as we move down the tracks and go through what could be future planning decisions. I think he provides some real world experience and examples.
Okay. Because I guess for me, in this capacity and thinking about how we exercise our executive powers. For me, in hearing this, it's as if there is some special circumstances or preferences that are granted to religious or something that's captioned as a religious use over any other entity that has whatever use they have. I say that because okay, so if 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 this religious liberty, okay, let me give a question. Where is the line drawn when the religious liberty violates the safety rights of those in the community? And for me, when I'm hearing this, it's as if we have the burden of proof to say that because this is a religious institution or some religious use versus another organization that is not titling their use as a religious use, then we've got to treat this entity that says it's a religious use differently from the way we would treat just a secular entity that's probably doing the same thing, but they are exercising and complying with the codes and ordinances and zoning requirements of that same religious entity. But yet, because this is a religious entity over here, we have to walk on eggshells and treat them in a different manner from which we would any other entity. For me, if you're violating or you're putting that community in a situation wherein there are safety concerns because of the activities, regardless whether they religious or not religious, then for me it kind of restricts us as within our executive powers to have our home rule decision making authority. And so that's where this is kind of messing me up, because what if I heard you say that these type of organizations or activities usually enhance the community? But what happens if the opposite occurs, that it actually harms the values of property in the community? So how do we determine that? And then how do we look at that's within our decision making authority and what we're charged with doing? How do we say, if you want to put this there, how do we now walk in exercising our best use for that property decision authority? So those are just some of the things. I probably threw all of my questions to you at one time and give you a chance to answer none, but I just wanted to kind of get that out there, because for me it's as if and I'm a pastor, and for me it's as if a religious organization is given preference over any other organization, when both of them may be causing the same harm. But we can deal with this secular organization in the manner in which we are supposed to, and that's in a manner in compliance with our codes. But if it's a religious organization, we got to pity patter around it and walk on eggshells and be frightful that they're going to say we're violating their religious liberties.
So a lot there. So let me try to globally answer your questions. In hopefully this comes through. RLUIPA is not a free pass for religious uses. So to be very clear, because your religious use doesn't give you an exemption from zoning ordinances or police powers or anything along those lines, it's not a free pass. You still have to comply with law. But RLUIPA is what Justice Barrett has written about, and some of the other justices have spoken about, is it's a great equalizer. What it does is it puts religious uses on the same level playing field as a secular use. So going to the heart of your question is how do you enforce your ordinances to make sure that the religious use is complying with police powers and being safe in the whole 9 yards as a secular use? You can do that You have to just establish a compelling governmental interest, and it can be done. So if there is something that is harmful for the community, that is arising out of religious use, that can be regulated, that can be addressed. In Reynolds versus United States, for example, back that case I talked about back in the 1870s, there the Supreme Court said, we're not going to address, your religious beliefs, but if your religious actions violate, the law and violate and harm the community, we could regulate that, and that went to polygamy. There's a lot of case law out there that also speaks to the issues of when if a religious use is doing something harmful for a community, it can be regulated as well. You just need to show a compelling governmental interest. The bottom line, though, is when you distill this all down, is if you can show equal treatment as to a secular use and a religious use, you will not have a RLUIPA problem. So if you provide for example, uh, uh, police enforcement on the streets outside of a homeless ministry, and you also provide for police enforcement outside of a school or an area or some other area where people congregate, you're not going to have, and there's been, community harms in those secular areas, you're likely not going to have a particular RLUIPA problem. Again, RLUIPA is not a free pass. It doesn't give religious organizations a free pass on zoning or police power enforcement or anything along those lines. It just really, it equalizes. It puts the same burden on secular uses as it does on religious uses. And that's really kind of where this comes down to. The case law very much does support that particular project and that particular line of thought of we just want to make it fair for religious uses, because before, when when RFRA was or when the Employment Division versus Smith came out, municipalities used their zoning to exclude religious uses. And Congress said, that's not what we want. We want the same type of secular uses as religious uses, not a preference, not something giving them religious uses more than anybody else, but just putting them on the same level playing field. I hope that answers your question.
You did. Thank you. Appreciate it.
I just want to ask one quick question. It seems like everything you've talked about has to deal with a legal action the city, county, or government entity took against another organization. Am I reading that correctly?
That's correct. Yes.
Okay. What happens if there is no legal action? We, in the terms that we are sitting in, which I'm trying to, if we're going to be trained on it, I want to be trained. We had no legal action and we performed no legal authority over any organization, whether religious or not religious. We might debate that, but whether religious or not religious, we didn't do anything. So I guess I'm trying to, in the things that you've trained us on, have you ever seen a situation where not even a commissioner of a commission writes a letter to an organization explaining that there are issues in the community and having those very clearly laid out? The commissioner runs that letter by legal and other commissioners before it is sent. And when that letter is received, I guess the organization reads it, whether agrees or not agrees, but decides to make some changes for the betterment of the community. Would that lean into RLUIPA as you see it?
Well, so RLUIPA is very narrow in terms of its application, which is zoning and land use.
Right. So I want to hold up there because I know I only got you till 5:30.
Yeah.
You said it's only locked in on zoning and land use. So if no zoning decision was made, if we did not block anyone from the usage of their land, no vote was taken to block anything, none of that was done, could RLUIPA be used? Because you said a little earlier, and I wrote it down, that you said this is these are very factual decisions. And I struggle with that because I've been trying to find the facts and the things that we've been working on. So if it's a factual decision, as you see RLUIPA, would RLUIPA be able to be used in that instance?
Well, if it's not involving zoning or historic designation or landmarking laws, then RLUIPA wouldn't necessarily apply. There might be other laws that apply,
Oh,
but
sure.
not
Okay.
not necessarily RLUIPA in that area. I'm just trying to think through the scenario you're thinking about, and I'm drawing a blank in terms of kind of what you're where you're going with that. But
No, I want to be clear. The
yeah,
situation that we have here is I, as the mayor, a commissioner, wrote a letter to an organization saying we're having several community issues with the way they are serving our population. We love their mission, love what they're about, but some things need to be curtailed if we are to live hand in hand, both helping and making sure our community is safe. That's all the letter said. That's all that was done. So I guess if that in that case, and by the facts of the case, that is why we are in here. In that case, do you see RLUIPA as a fair lane of the law to use?
I, I do. Well, okay, so I haven't reviewed your letter, so I'm guessing at this point in time, and I hate guessing, but
But I
if
guess
the letter,
if the letter has no forcible impact, let's not worry about what's in the letter. The letter has no forcible impact.
uh,
So if a letter has no forcible impact, I'm not blocking you or making any decisions based on your land usage. I mean, like you said, it could be other legal avenues, but I'm just wondering, is RLUIPA the legal avenue that you would advise?
well, let's think about it this way. This is you had an issue with an entity called the Well, correct? And the Well is a shelter. Is that right?
Sure.
Okay. And so with and again, I haven't reviewed your letter, so I don't know specifically what it said, but if that letter
I
went
got 2 minutes.
to
It matters that I'm trying to have. I know we got 2 minutes. 2 issues. Okay, two. I guess what I'm trying to figure out is a letter, just plainly a letter with no forcible legal impact.
uh-huh.
Does that trigger RLUIPA?
Again, I'm going to say it depends. You know, there are some letters that it has, I've seen it has, and some letter that it hasn't. When it has, it goes to the use of the land. When it impacts, you know, if you don't follow these prescriptions or you don't change your thing, then we're going to withdraw your zoning approval or your land use approval. Then that would impact RLUIPA. RLUIPA would come into play there. Um, if there's going to be some sort of,
So just the mention of action triggers RLUIPA.
yeah, yeah.
Oh, I didn't see that in the presentation. So it's good to know that if we just talk about it, then that triggers RLUIPA. If we say people are in the street and they are fighting and hurting citizens every single night, then us coming together as a commission and talking about the safety of our community, that triggers RLUIPA.
That would not trigger RLUIPA.
Okay, if we come together and we talk about it and we decide to write a letter to that organization saying we care about the safety of our citizens and the safety of the people you all are serving, and by mention that we are serving as a community. Got some pastors on here, members of churches. I'm just trying to figure out if you just write a letter, hey, can we work together? Let's figure out some things. But at current, the way things are going, it isn't good for our community as a whole. Can we figure some things out? You write that letter, that triggers RLUIPA.
If the letter includes in there that we're going to take specific steps that affect your use of the
It didn't say
land,
we. It
then
came from one commissioner. I want to keep going back to that. It came from one commissioner, had no legal authority, and showed no ability to have a majority even in that decision. I know we're on 531. I'm just wondering, would that trigger RLUIPA?
I would think it would, yeah. Because you're impacting the operations, you're impacting the use of their land by having them curtail their operations, and if they don't, then there would be a threat or implied threat that their use would be revoked or not permitted. So again, I can't comment as to the content of your letter because I don't know what your letter said. I can't comment about everything that happened in litigation because
Yeah, no,
I was there.
to me, the
I'm just
biggest
talking in
thing.
general. If you do something to impact an existing religious use, then it's probably going to trigger it. If you're talking about general health, safety, and welfare concerns, say, it probably won't. But it's again very
So
fact
if you are
specific.
talking about health, safety, and welfare, right?
If
That
it's
that that those concerns can be brought forward.
Can I ask for just real quick, because I do think Dan mentioned this in the presentation. Dan, when you say, and I'm just seeking clarity too, that while it might trigger, that doesn't prohibit the fact that we would be able to do or present a compelling governmental interest in addressing some issues that may be going on in the city. Is that a fair statement?
absolutely, yeah. If you have a compelling government interest, if you know that you can certainly do that. You can certainly take action. You just can't treat the church or religious use differently than a secular use that has perhaps those same issues.
I hear that. I think the one thing I was trying to come to is a conclusion that the actions of a commission that have legal authority have to be treated differently in the law than just letters. And so a singular letter of no forcible impact that had no threatening language or anything to that nature. I'm just wondering, again, a different legal avenue maybe, but doesn't seem like RLUIPA is that legal avenue.
I think if you kind of look, for example, just by analogy, in the zoning context, let's say somebody comes before the zoning board for a variance, and you as the mayor, um, I don't know if you're the mayor or not, but if you're the mayor and you send a letter saying, "Hey, I'm speaking on my own behalf. I'm not speaking as elected official. I'm not speaking after the council, but I oppose this variance for X, Y, and Z reasons." A court generally is going to find that to be undue influence, and it's generally going to determine that you can't do that, and the determination of the board to deny the variance because of what you said as elected official, even though you're not acting on behalf of the board, is going to be undue influence. And I think perhaps that might be the most closest analogy it sounds like to maybe what happened in this particular situation. But again, I don't know. I wasn't a part of this whole thing, so I want to disclaim that coming out. Yeah, I would just talk to your attorney. You got a great attorney. Talk to your planners. Make sure that when you're making these decisions, you're thinking about treating the religious use fairly, and you're thinking about also what is that overall compelling governmental interest, and what's the least restrictive means that can be imposed when you're making your zoning and landmarking decisions.
Dan, thank you so much. We appreciate your time. We appreciate the training, and it was educational for us. So we appreciate you.
Yes,
All right.
thank you,
Well,
Dan.
thank you. Appreciate the opportunity. You have a great evening.
Do we need to adjourn? I'm assuming. We'll make a motion to adjourn the work session.
So moved.
Here in the first, do I hear a second? Here in the first and the second, all those in favor show by sign of aye. Aye. We are adjourned. Good evening. We would like to call this Brunswick City Commission special call, not special call, sorry. Brunswick City Commission regular scheduled commission meeting for Thursday, March 19th, 2026 to order. If we could all please stand for our invocation and pledge of allegiance. And we will be having our invocation by Mr. Elder Coach Terrence Haywood. You know what I mean? We thank you for your work in the community, for loving on our kids and loving on our community as a whole. So we appreciate your leadership.
Yes, sir. And yes, ma'am. Y'all thank you for having me. Let us pray. Our Heavenly Father, we thank you for this day, Lord, and we just humbly come to you, Lord, right now, thanking you for all you've done and all you continuing to do. Lord, right now, I thank you, Lord, for these commissioners, Lord, and the mayor, Lord, for the the spirit of servanthood that you've given each and every one of them, Lord, to serve our community, Lord, to help build up our community, Lord. And I just ask that you cover and keep each and every one of them, Lord. And I thank you, Lord, for giving them the ability, Lord, to want to make decisions to better this community, Lord. Right now, Lord, I ask that you just clear their hearts, their minds, Lord, and give them the wisdom, the guidance that they need to make the right decisions, Lord, for the city of Brunswick, Lord. And right now, Lord, I ask that as they conduct this meeting, Lord, that everything is done decently and in order. We love you, we praise you, we thank you. And in Jesus' mighty name we pray. Amen. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Coach Haywood, I hear you in trouble for having on Bluetooth. That's what I heard. That's what they tell me. That's what they tell me up here. That's hey. We thank you everyone for being here. The first thing we will move to is the approval of the agenda. Is there any amendments or subtractions?
Yes, Mr. Mayor, I have an amendment.
Yes.
I move that we add to the agenda as item number 2-A, public hearing new alcohol license.
Hearing the first, do I hear a second?
Second.
Hearing the first and a second, all those in favor show by the sign of aye.
Aye.
All those opposed, the same. Hearing none, the motion passes. Any other addendums or subtractions?
Mr. Mayor, I make a motion that we defer. There's the item at,
Number 3.
it's number 3.
Mhm.
Considering approval of the financial reports as of December 31st, 2025.
Hearing the first, do I hear a second?
Second.
Hearing the first and a second, all those in favor show by the usual sign of aye.
Aye.
All those opposed, the same. Hearing none, the motion passes. Any other addendums or subtractions? Hearing none, we will make a motion to approve the agenda as amended.
Mr. Mayor, make a motion that we approve the agenda as amended.
Hearing the first, do I hear a second?
Second.
Hearing the first and the second, all those in favor show by the usual sign of aye.
Aye.
All those opposed, the same. Hearing none, the motion passes and the agenda is adopted. Is there any public comment, City Clerk? Wonderful. With that, we will move on to consider approval of March 4th, 2026 regular scheduled meeting minutes. Do I hear first? Or is there any addendums or subtraction with City Clerk Atkinson? If there are none, then I'll open it for a motion.
Mr. Mayor, I make a motion that we consider approval of the March 4th, 2026 regular scheduled meeting minutes.
Hearing the first, do I hear a second? Hearing the first and the second, all those in favor show by the sign of aye.
Aye.
All those opposed, the same. Hearing none, the motion passes. As number 3 is deferred, I'd like to take this moment now to welcome our special guests. I do that so y'all don't have to listen to the update on municipal court unless y'all like to stay and hang out. With that, before we get started, I just want to say a while ago, I think I was at the Martin Luther King Day parade, and Miss Darlene pulled me to the side and said that I had some homework and some stuff I needed to do, and I needed to make sure I was in place. And she stayed on me all the way until right now, into this weekend. So I want to say, before I even get started, Miss Darlene, thank you for caring about me enough to make sure I was in place and not out of place. And we appreciate your leadership and love in our community. I want to acknowledge a few of our Brunswick residents before we get into the proclamation. I will first want to offer a big acknowledgement to our president and the president of Zeta Phi Beta Sorority Incorporated, Eta Gamma Zeta Chapter, Miss Tanya Lanham. If she could please stand. Thank you so much for your leadership of this organization. Every single thing that we do in the city of Brunswick, we always see you all out there. And not only out there, but loving on the community, making sure that people have all that they need. But you're also there with a message of encouragement and love. And so I just want to say, from your mayor, from your commission, that consistency has mattered. That consistency has mattered to us to make sure that when we look to our left and we look to our right, we're never by ourselves because you all are right there beside us. So I want to thank you for your leadership. And to the president of Phi Beta Sigma Fraternity Incorporated, Lambda Beta Sigma Alumni Chapter, Mr. Coach Brian Edwards. I'm gonna keep saying, Coach, I'm gonna keep saying that you are the leader that we have always seen in you, whether you are on the sidelines, whether you are making sure kids have the availability of sports, but not only that sports, you wrap that into scholastic growth, but you also wrap that into the growth of them as the human being. And you also didn't stop there. You took that leadership from the school and you implanted it inside of your brotherhood. And so we are happy to see you all spending just a little bit time with us. But for the people who are just going to be in and go out, we are even more thankful that they have helped build the man with your kind of character that you have chose to call Brunswick home. And Brunswick is thankful to have you in our community. So we are thankful for your leadership and all that you do. To our proclamations. Whereas Phi Beta Sigma Fraternity Incorporated was founded on January 9th, 1914 on the campus of Howard University in Washington, D.C. by three visionary young men, A. Langston Taylor, Leonard F. Morse, and Charles I. Brown, who sought to establish a Greek letter organization rooted in the ideals of brotherhood, scholarship, and service. And whereas Phi Beta Sigma has led nationally and internationally through groundbreaking innovations, including being the first Black Greek letter fraternity to establish alumni chapters, youth mentoring clubs, a federal credit union, and chapters in Africa. And it remains the only fraternity constitutionally bound to a sorority, Zeta Phi Beta Sorority, incorporated and founded in 1920 with the assistance of its members. And whereas today, Phi Beta Sigma Fraternity Incorporated stands as an international brotherhood with hundreds of chapters across the United States and abroad, committed to uplifting communities through education, civic action, mentorship, and programs that advance the fraternity's motto, culture for service and service for humanity. And whereas the state director of Georgia, Dr. Walter Stevens, along with his brothers from across the state, from Atlanta to Brunswick, from Athens to Cuthbert and beyond, will gather on Jekyll Island for a joint state conference with Zeta Phi Beta Sorority Incorporated. And the city of Brunswick recognizes and celebrates the long-standing blue and white family bond between Phi Beta Sigma and Zeta Phi Beta, whose collective efforts continue to strengthen communities through service, leadership, scholarship, and civic engagement. Now, therefore, be it resolved that I, Cosby Johnson, as mayor of the city of Brunswick, along with my fellow commissioners, do hereby extend a warm and distinguished welcome to Phi Beta Sigma Fraternity, incorporated as you convene for your joint state conference. We applaud your more than a century of service, leadership, and commitment to humanity, and we are honored to host your brotherhood in our coastal community. May this conference be enriching, collaborative, and inspiring for all who attend. If we could have the brothers come to the front so we can grab a picture with you all.
Good to see you. Thank you so much. Thank you.
Now, now y'all got to make sure you visit your brother's building, the Roosevelt Harris Senior Center. Make sure you swing by to show it some love because his vision, leadership in our city has guided us for a long time. And it's still his steady hand and his steady thought that we all emulate here as we continue to grow the city. So to Mr. Harris, thank you so much for all that you've done to our city and for our city.
I just wanted to take this point of privilege to say how honored I am to have the first African American city manager for the city of Brunswick in the house and to be a part of this this great organization. So, Mr. Harris, if you would please, Mr. Roosevelt Harris, please take your honorary stand and let us see you. It's an honor. I watched you as a younger person, and I watched how you had to maneuver and tread in waters, and how you stood for not just equality but for equity. And I am so honored to be sitting here tonight because of someone like you.
Now for our next proclamation. Whereas Zeta Phi Beta Sorority Incorporated was founded on January 16th, 1920, on the campus of Howard University in Washington, D.C., by 5 visionary women: Arizona Cleaver Stemmons, Pearl Anna Neal, Myrtle Tyler Faithful, Viola Tyler Goings, and Fanny, I'm going to say her wrong, Petty. That is Fanny Petty Watts. Come on, Fanny Petty Watts. I'm going to never forget that. Known proudly as the 5 Pearls. And whereas these founders established a sorority committed to the principles of scholarship, service, sisterhood, and finer womanhood, choosing a path focused on academic excellence, community uplift, and social progress during a time of significant racial and social challenges in America. And whereas Zeta Phi Beta Sorority Incorporated has distinguished itself through a history of groundbreaking firsts, including being the first NPHC organization to charter a chapter in Africa, the first to operate a national headquarters, and the first and only sorority constitutionally bound to a fraternity, Phi Beta Sigma Fraternity Incorporated, demonstrating a legacy of leadership and innovation. And whereas the state director of Georgia, Ms. McKay, the first elected state director, along with members from Atlanta to Brunswick, from Athens to Cuthbert, and across the great state of Georgia, will gather this weekend on Jekyll Island for a joint state conference. And the city of Brunswick proudly recognizes and welcomes these distinguished women whose presence reflects excellence, dignity, and the spirit of community and leadership. Now, therefore, be it resolved that I, Cosby H. Johnson, as mayor of the city of Brunswick, along with my fellow commissioners, do hereby extend a warm and heartfelt welcome to Zeta Phi Beta Sorority Incorporated and commend their continued dedication to meaningful service, empowerment, and educational advancement. We will ask that the ladies come on up so we can grab our picture. Right. Finer when.
Exactly.
Thank you. Thank you all for being with us. I want to say this before you all get out of here. I know it takes a lot of work to bring a state conference anywhere in the state. It's a lot of work that you all put in to organize these things. But before you all get here, we know it's a lot of work that goes into the decision-making process of where you all choose. So we want to give a big shout out to our two local presidents, because we know they had to do some work internally for them to choose the beautiful community of Brunswick for this auspicious event. So we want to say thank you for that work that was done quietly and over time and inside of the brother and sisterhood, because Brunswick will enjoy you all while you are here. So thank you so much. With that, we will move on to our update, and an update from Municipal Court. 2A, I'm sorry. 2A. Deputy? Where's my deputy? There we go. Want to read this correctly. We have a new alcohol license, if I'm correct, for B&J's Steak and Seafood. The owner is Terry Dowling. The address 1600A Newcastle Street, on-premise consumption of beer and wine.
Mr. Terry is here. Well, good evening. Mr. Terry Dowling is here in the back. Okay. All right. Do apologize, but Mr. Terry Dowling is here, the owner of B&J Steak and Seafood. He will be, like you said, at 1600A Newcastle Street for beer and wine on-premise consumption. It is a steak and seafood restaurant. He does have, he has been to the MPA. He has submitted everything and met all the requirements. Mr. Terry?
Thank you. Mr. Terry, if you could please come up for us.
Sorry.
No, you're all good, man. You're a business owner. We're assuming you're out working. Yeah, but we thank you for being with us this evening. If you could just kind of tell us a little bit about what you plan on doing at B&J's and your service there.
Okay, well, I've had B&J's in Darien for almost 25 years. And I have a beer and wine license. Now, I don't sell very much beer and wine, but I do have beer and wine for somebody, that would like a beer with a meal. So I'm not going to do buffet over here. It's going to be menu only because the space is a lot smaller, but pretty much the same, same menu, adding a couple items and just trying to do, I'm ready to come home. You know what I mean? Born and
That's
raised in
good.
Brunswick,
That's
I'm ready to
good.
come home.
We ready to have you home. We're ready to have you home. We appreciate that. With that, I will open it for any questions or comments from the commission.
What took you so long?
Made me work, made me work too much. And I made my wife, she's gonna come back to work.
Oh, so it's good to see you, Terry.
Open day. Thank you so very much.
Can you just tell us a little bit about the hours you're thinking about being open and
To
days
start
of the
with,
week?
I'm sorry, I'm gonna try to do Monday, Tuesday, Wednesday lunch only probably in the beginning days, and Thursday, Friday, Saturday, from, lunch and dinner. So,
Close on Sunday.
right, closed on Sunday. Yes, sir. Yes, sir. 8 or 9, I'm still trying to make up my mind. Definitely no later than 9, but 8 or 9. Okay. And then Miss Lena, done a lot of help, helping me with that stuff as far as like, them guys are wonderful, man. I've had more help here in the first 2 or 3 weeks getting this thing done than I've had in 25 years. And I'm telling you, I'm really, really grateful for it too. So
And then sometimes when we get out of our commission meetings, we need places to eat.
I'll be there. I'll be there.
Any other questions or comments? Hearing none, we will open it for public comment. I usually leave it open for about 20 seconds. Seeing no public comment, we will close the public comment period and come back to that. Any additional questions or comments from the commission? Hearing none, we will open it for a motion.
Mr. Mayor, I'd like to make a motion that we approve the on-premise consumption of beer and wine for B&J's Steak and Seafood at 1600 Newcastle Street.
Second.
Hearing a first and a second. All those in favor show by a sign of aye.
Aye.
All those opposed, the same. Hearing none, the motion passes. Thank you so much. We appreciate you. Thank you. With that, we will now move to number 4, which is update on municipal court.
I gotta be patient and wait on my slideshow. I came prepared. We're good? Okay. Good evening, Mayor, Commission. How are y'all this evening? All right. I'm Brittany, the clerk downstairs. And tonight I am going to tell you a few key points about municipal court. I'm going to go over the growth, the processing and the efficiency, the financial overview, the innovation and solutions, and our future incentives. So first, I'm going to go over how we're going to navigate through our future. This is going to be the first, 2025 was the first full year that we had both of the new judges on the bench. That would have been our Chief Judge, Jason Clark, and our Pro Temp Judge, Rick McElvain. And we've seen the fees and the fine collections have been improved. The increase in compliance has also improved. And our outreach from the court to the community, we've also improved too. We've also fostered new partnerships with Georgia State Patrol, Glenn County Board of Education, and the State of Georgia Port Police, along with also keeping the one we have with BPD and making it better. We also continue growth with our night court by meeting the community where they are. With that, we have 3 set court times on Wednesdays for the court. The first week is at 9:30 in the morning. Then the third week is at 1 o'clock. And then the last one is our night court, which is at 5:30 in the evening. Whoop, wrong way. All right, so case processing. So currently, most cases are resolved within 30 to 60 days, and that's once we receive the tickets and we input them into the system, we'll have them resolved within that much time. Last year in 2025, we closed over 2,417 citations and processed over 2,492 new cases. And the prior year in 2024, we closed 1,889 cases and processed 2,219 new cases. So a quick snapshot of financials from 2024 to 2025. 2024, the revenue was $241,568.31. Expenses occurred were $202,854.69, with a net income of $28,713.62. And then last year, it's going to be unverified, waiting on the financial audit to finish, with 258,878. Sorry, got that backwards. 258. I might have said that right. I have these numbers. Too many numbers. Yeah, there we go. And then for expenses, 186,354.64, with a net income of $72,523.92. So we were able to get the expenses down a little bit more. So next, we're going to have our innovative solution. We want to implement an e-filing system for our cases. We want to try to get collection of unpaid citation and fines. We want to increase our online access to court records and host community education sessions on court processes and citizen rights. For the e-filing, there are two major vendors, which are Odyssey and Peach Court. I'm sure there's other ones too, but those are the two main ones throughout the state, which we haven't looked into any of these, but those are two big ones. And as far as everything else goes, we don't have anything on those either, but definitely we'll be looking into those. Okay, so for future incentives, we want to look at the technology integration by exploring and emerging technologies for potential integration into court operations, and then collaborating partnerships by exploring partnerships with other agencies to achieve a goal for a merged court system. So hopefully we can get a system across all of our court systems so that we can share our information with other courts, and they can then in turn share their information so that we're not crossing. So that's a goal. Maybe one day. But then lastly, we have where we do the different payments. We have our Justice One link. We do it through Government Window, and then you can either come and pay in person. And thank you for your time. And do y'all have any questions?
Thank you so much. Questions or comments from the commission?
Thank you for the presentation. I think this is the first time we had a presentation from municipal court since I've been serving 2024, and I appreciate it. One question, well, two. You said fees and fines collection improved. How did that improve?
Fees and fines. Let me go back to my.
Okay. No
All right,
problem.
fees and fines. The collections that we.
You said improve when you were saying improve.
Oh, how they
process.
improved. Oh, okay.
Is it-
So just over the last year, we've just had more compliancy. I feel like we, as a court system, have had a better outreach to the community. And so they, in turn, come to court. We have less bench warrants going out. We have a higher rate of people coming to court. So it's just less overall.
Okay. Okay.
Yeah, because before, Brian would come on just trial dates, and now we've taken trials to pretty much maybe 3 or 4, when they used to have an entire day of it.
And I think the biggest part of that improvement is I am in court every time we have court now. So on, even on arraignment dates, when the, when the calendar is the longest, I am always here. And what we've started to do now as well is that an arraignment date would typically only be a date where you would come and plead guilty or not guilty. And if you're pleading not guilty, you're going to get a bench trial set. You come back to court when it's set, typically 30 to 60 days. What we started administering is I come on arraignment dates, and if you desire to speak to me about your case, you line up at the end of this table. Normally the line's out that door, but we go through case by case, typically with minor traffic infractions and citations, and determine the severity of the case, and then whether or not there's a resolution that can occur on that date. If there's not, and this is what Brittany was talking about a second ago, and some people want to go to trial no matter what, then they plead not guilty. There are other more severe cases that I would not attempt to work out on an arraignment date. They plead not guilty. We've also administered having public defenders, and they're not actual public defenders. They are private criminal defense attorneys, but they are either donating their time or they are working at the public defender rate. They also come on arraignment dates and bench trial dates. We typically have a public defender, what I call a public defender, at every court session, which also helps significantly because we can process public defender applications on site. The judge can review, which usually occurs while I'm going over the case with a potential defendant. If he approves that day, public defender can typically work with the person, let them know their rights, go through the waiver of rights with them, and, generally give them an idea of what they're looking at as their case might progress. A lot of times or I would say most of the time that occurs when there is a more severe charge, like a DUI, reckless driving, disorderly conduct, shoplifting. Those are charges that are going to typically permanently impact somebody's criminal record. Those are charges that, speeding tickets roll off, speeding tickets can get reduced, seatbelt tickets, those types of things where they're lesser, we can try to work with somebody if they have a clean record. So I think that by processing the vast majority of the cases on an arraignment date where the person says, okay, I'd like to resolve it right now, right today, let's go in front of the judge. We process the paperwork. Usually Gina is sitting where I'm sitting today, and they walk from where Brittany is to here, and they pay their citation, and the court case is done. So I do think that being here on arraignment dates and on bench trials while the long day has significantly improved our ability to collect. People want to have these things done. They want to come one time. They don't want to have to complete not guilty, try to work something out, come back. I think that the system is working pretty well.
What have you modified to reduce the amount of expenses? You had a significant reduction in expenses.
I honestly do not know. When we ran those numbers and saw that, I do not know what we've done to make it better. But we will be looking into it because that is a great deal. Whatever we did last year, we are going to keep on doing. I'll tell you that.
What form of payments do all accept on site?
We accept cash. We accept cards. I think that's it. Yeah. Oh, money order. Yeah, money order. Sorry, I always forget that one.
We accept firm checks too.
Checks.
Bank checks?
Lawyers are writing checks
Yeah.
typically. And then the QR code does allow you to pay, I believe, with Apple Pay if you scan the QR code.
Yeah.
Oh, okay. Do you find that most of your clients pay via cash, on checks, when they're here on site?
When they're on site, they pay cash. Some of them will pay credit card, but credit card charges an extra 5% through the company that we have. And that's not our rate. That's the rate that that we use, the system that we use. So they just prefer to pay which I don't blame them. They would rather pay cash. And so that's that. The government window is not as high. So some of them will use that one, whichever one they want to use they can use.
With the government window?
The government window is the one through the actual city.
Do you get an instance like it was paid, or how do you get the record?
Yes, ma'am.
Okay.
We get it goes straight to the city.
And what about night court? How many people do you all see? What's the number count for night?
Night court is,
Do you see,
it's a higher rate. Like the first night court we had 40, I believe on
On the docket.
it was like 47 on the docket, 40 showed up. 5 called the next day or something. So 2 actually didn't show up.
I mean, to be honest,
It was very full, like.
The
one
first
court
one.
was so full.
first
They were
one.
all the way around.
but it has not been utilized since then?
no, sometimes I think that somebody's not gonna come to court. You could have it morning, noon, night, you could have it at midnight, and they're just not gonna.
And they pick night court on their own, or do we select?
Typically, yes, because night court is most often when we do bench trials, it allows for attorneys who are defending clients, if they're coming to bench trial, we don't have conflicts. They won't say I'm in state court that morning, yada, yada, yada. But, I don't know, even those that pick it still
Yeah, I mean,
manage to not come somehow. So
there will always be those people that do not want to come.
How long you usually have, 5:30, 7:30 on those long nights?
yes, I would say,
That's
probably.
the latest we've ever been is 7:30.
yes.
Okay,
Yeah, and that was a long night.
thank you. Thank you very much.
Commissioner Atkins Williams probably took most of my questions. But so I'll just hit on the night court part of it. So the impact of night court on your caseload.
I feel like it's done pretty well. I feel like it's because we reached out to the community and we gave them an option so that they would not miss work and that they're able, especially the kids, they're not missing school because, I mean, there are some of these 17-year-olds and a few of them that have a little lead foot and they've had to come to court. So it's made it so that they're able to come at night.
Okay. And so my last question is, what's your average total number of cases per year?
So that one was on that spreadsheet, or not spreadsheet, that one was on so the citations were how many citations actually came in, but the actual cases processed were the 2,492. That was what we actually processed. So that could have been in court or through the window.
But I would say that the numbers starting in 2023, moving forward, when we began having our relationship with Georgia State Patrol, I would say that we saw an increase, and it ebbs and flows as tickets are issued. Summer or holidays, it seems like there are much more tickets being issued around now, and then around August there appeared to be a dip. But I would say the last 3 years we're probably around that 2,500 case mark. But that's, and we also, and I know this wasn't in the presentation, but the judges are also working. We're trying to reestablish the relationship with the college police and hospital police. We used to process cases, and I know everyone's aware we have a new parking ordinance, and a lot of what they're looking at, it revolves around the enforcement of parking. And so I think we have a meeting, or we're going to have a meeting set up to the judge, and they all have their own chief of police. So we're going to look at that as well.
And so as a community, the impact of the changes that you've made in municipal court, how have you seen that impact the safety issues as far as those matters go that run through municipal court? Brian or Brittany?
It is my belief that we do things in city court to try ensure, we are trying to ensure compliance. We are also trying to do what we can to assist people from making mistakes that are nearly irreversible in certain circumstances. While we have lesser offenses, I guess you could say, the most severe offense in municipal court is a DUI. But even then, when you have a citation for no insurance, reckless driving, a high speeding citation, driving without a license, those can carry significant penalties. And most of the time that results in a suspended license. Once that license is suspended, and we see it every week, it is a vicious, vicious cycle to get out of the going back and forth, trying to go to work. You don't have a car, you can't drive. If you do in an emergency, because you got to try to keep your job. We do what we can, and I think we do a really good job of working with people to try to avoid those types of mistakes. We do have compliance court where if someone is coming with something like that going on, what we will typically do is allow them a 30-day window, bring paperwork back showing that you're starting your reinstatement, bring paperwork back showing that you went to a risk reduction class for your driving. Generally bring paperwork back just showing that you're working on something through, and we will work with you to make sure that we don't kind of have that. I think we do a really, really good job of that. I would hope that the general public looks at it that way as well. And so from the safety perspective of that, I think what we want to see most often, and I think it would be most related to driving without a license and or without insurance, that seeking compliance to make sure somebody has insurance, in my opinion, is one of the things that we need to focus on, because if they are out there driving and they do get in a wreck and hurt somebody, insurance is the only thing there that could protect that person that's been harmed. And in the same sense as if they're out reckless driving, speeding too much, and we do have a requirement that certain speeds, and I think everybody should know this, 20 miles an hour and over, the judges are going to require a risk reduction class, meaning you go to defensive driving class, and they're also instituting community service in those situations. So again, trying to get back to the community or showing that you're going to have consequences if you do this, but we want you to try to go through these consequences to better, hopefully yourself, better your position. If you get your insurance, get your license back. That's the biggest thing. And then maybe learn something from one of those courses to drive better. I hate to say that, but that's kind of been our goal. And I tell people all the time that they always come with school zone tickets or super speeder tickets. You can do whatever you want. You can say whatever you want, but when we walk in front of the judge, he's not going to accept anything unless you've done some community service or gone and gotten your classes done.
So it's like kind of sort of like a diversionary.
We do, and we have, that's another thing to bring up. We have instituted a pretrial diversion program for shoplifting, disorderly conduct charges, and essentially first offender charges that they can go through. So we provide options. Really, we're trying to work with people to make sure that they're going to have to pay your fine, but let's try to get you in a better situation than when you came in.
And a couple quick questions, and Ms. McDuffie probably can chime into. I'm personally just not clear on, does municipal court operate managing their own budget, their own line, and that goes all through your office? Or I know that
No, they do.
Okay.
They have line item budgets, and we can look at it and know exactly what changed from last year to
yeah,
that kind of thing. But yeah, they manage and present their own budget.
perfect.
Yes.
And I guess one of my thought processes, and as Bren and you were talking to Brenda about expanding services and things like that, what comes to my mind is, do we have the appropriate facilities for this expanded service? You know, when we have multiple tables and people all meeting in the same room, are we providing the right legal privacy for all parties involved and things like that? So I'd love for us to kind of think about that as I see surplus in the budget and I see drapes blowing because there's cracks in the window. Like, does municipal court, have a surplus step up a little bit on maintenance and all that kind of fun stuff?
Again, they are part of the general fund.
Mhm.
So nothing goes directly,
Yeah.
They do process their budget separately, but it's part of the general
Perfect.
fund.
Perfect.
Yeah.
Want to make sure that they got what they need. And if they're doing good managing their budget, that we reinvest in that. Thank you.
Brittany, and I know you said you wasn't sure exactly what took place for you all to have a reduced amount in expenditures, but what makes up the expenditures? From the top of your head, what counts as expenditure? Don't look at her, you should know.
I guess our expenditures would be what we put out or what we pay for our courtware system, what we pay for. So we bring in what we bring in our fees and fines. We also have to pay out back to the G, it's an acronym,
Drug
but it's the fines and fees through the state. You
Okay.
then have to pay the state their money, because when people pay a fine and a fee, there's a certain amount of money that you have to pay back to the state that goes to different funds. Like there's a fund for drugs, there's a fund for police, there's different funds.
Mhm.
And so there's so much money that has to be allotted back to the state. So that's part of the money that at the end of each month that I have to pay back out and send back over.
So if they are paying through Apple Pay or the QR code or cash, you don't pay through those, you don't have to pay those funds.
No, so all of the money comes in to us.
Okay.
And then from there, it's one money, I guess, one
Okay.
money.
So are y'all, and Mrs. Mc,
I don't pay any of my other bill. Like we don't, finance pays our bills.
so it comes out, Ms. McDuffie, maybe she could answer.
Okay.
So their salaries is budgeted through their income only, their separate entity?
No. Their budget is in the general fund. All the revenues that come into the general fund, property taxes, sales taxes, is general fund. The municipal court is a line item in the general fund. Their expenses is a budget in the general fund, which is separate. And I would venture to guess that the difference is probably because we did not have a municipal court clerk for a time during that year, and the salaries were low. Their operating is very, it's just like everything else. 70% of their budget is probably salaries. And if you have such a large decrease, it's probably because we had a gap in, or a vacancy in that particular budget.
Okay.
That would make sense, because she was not there for, what, 6 months? There wasn't somebody there?
Yeah.
Okay,
Okay. Thank you.
there we go.
Any additional questions or comments?
Thank
Thank you,
y'all.
hard work,
Thank
yeah.
you so much.
Glad you're feeling better.
Just like to say, Brittany has worked really hard and the court to make some changes, and we are working to improve the service to the community. And I want to thank her for her diligence in the work, and the judges as well, because there is a significant change in how the judges are imposing fines and processing cases. And that's made a big difference, as well as the work that Brian does. Thank you.
Thank you. Seeing nothing else, if there's nothing else from commission, we will executive session. No, stop. Stop.
Mr. Mayor, I'd like to make a motion to adjourn.
Like, second it.
Here, the first and the second. All those in favor, show by sign of aye. Aye. All those opposed, hearing none, we are adjourned.